small companies are panicking because they're being told they have to do all sorts of things with the data they've got. They've got to have audits, they've got to have paper trails, they've got to have double opt-ins. I mean, imagine if you're a company with one employee, having to do all that sort of thing is really, really expensive and actually really scary. So what James is going to do, he's going to uncover a little bit about what GDPR actually does mean, and specifically within the context of politics. And I should really introduce him. James is recognised as a leader in data protection with wide jurisdictional experience, having practiced as a litigation lawyer in England and Wales, the US, and also in Canada. James has extensive experience in intellectual property, commercial litigation, alternative dispute resolution. You want to tell us what that is? That sounds and other matters of privacy and data protection. Now, we've worked with James for years, and most recently, we were talking to him about how the bill is going to be implemented in Britain, and James has actually advised the government on some of the amendments that are going through the Lords as we speak to the bill before it comes into force. So, without further ado, James.
No pressure there, either in terms of keeping you entertained or otherwise. There we go. Yes, thank you for those kind introductions. Just to sort of explain, since I was asked, effectively my core practice is litigation and regulatory compliance, and that has more and more been regulatory compliance in relation to election law, data law, and advertising control, which actually in Europe also feeds into the messaging that you can use, at least in Western Europe. And that's because it's my sort of Alcoholics Anonymous moment. I'm James and I like politics. In this room, that's not so embarrassing, but normally in legal circles, that's not what I intend to say. And what I will try to do today is to run you through the core aspects of what's happening in data protection regulation. And as you've already heard, if you do anything with any European citizen's information, something as simple as the name and the email address, then this regulation has a very long arm. In fact, for the Americans in the audience, you see, the Europeans are getting a bit like the US Department of Justice, which tends to view the world as running according to US law regardless of where you sit. Well, that's what the Europeans are doing with this regulation, and therefore, as you've heard, if you do anything with European businesses or European citizen data, you don't want to ignore it. So, you've heard that this is the sort of the boring legal bit. I can't quite see what's on my slide, so hang on a second. This will hopefully try and avoid me looking over my shoulder the whole time. This is just a quick summary of what's happening in May 2018. These are uniform rules across Europe. Now actually Europe has had uniform rules on data since 1995. The worrying thing is that most people have been ignoring them. And so that has in part led to some pretty hefty fines. And so I start, if you like, with the comment at the bottom of this slide. The European system will allow fines of up to 4% of worldwide turnover of your business. Now that's not much fun for anybody. Worse than that, the European Commission has decided to take advice from the team in Brussels that deals with anti-competitive behaviour. And if you have the misfortune to know anything about this, what they then tend to do is they look at a company like Microsoft, which is obviously huge and global, and it has corporate entities all around the world. It has a Belgian entity, a French entity, an Irish entity. And typically, under legal rules, you would simply say, okay, well, the person who did something wrong here was UK Microsoft. And so you'd look at UK Microsoft's balance sheet, and you'd find the UK Microsoft. Not with the European Commission regulatory team. They say, no, Microsoft is Microsoft. And so it's 4% of the entire global company, parent company turnover. That's why these numbers could be truly horrific if you're big enough. And quite frankly, even if you're small, 4% of anybody's turnover is not a number that you want to have. So, as I've already said, you've got to think about this if you do anything in Europe or with anybody European. And the key changes that are coming in are to do with keeping records, thinking about the security evaluation. It's no longer enough to buy some computers and use them until they start falling apart 10 years later. You've actually got to think about whether or not technology has moved on, and you need to do an annualised auditing process. So that's the quick summary. Now, one of the other interesting things, forgive me for borrowing a little bit from the UK regulator, but they have the odd nice image. The yellow box are the present 8 data protection principles. Now, these are uniform across Europe, but this is how the UK regulator puts them out so you understand. They're pretty straightforward kind of concepts. You know, make sure that you keep things on a secure basis, think about people's rights and so on. But one of the fun things with European law, and the way it's developing, is we've reformulated these. We've managed to turn them into 7, and yet we've added a new one. It's interesting mathematics here. So what you've got on the right-hand side is that I've just noted that the new principle is accountability. And that is all about putting more onus on you as individuals to annually record what it is you do, what it is you think about. So if you run on a board system, or you've got a company director, or if you're just a one-man band, once a year in your internal records, you want to be showing, today we thought about data, today we thought about our computer systems, and we've given ourselves a clean bill of health. I mean, that might sound a little silly, but effectively, at heart, you have to do that at a minimum. Because should you have any complaints, or should you have any of the European regulators decide to do a random audit, and they can all do random audits on anybody, and they don't see that once a year you're doing that and showing that you're thinking about your accountability, that's an automatic fine. Now, it's not the 4% fine, because they will be graduated, unless you're in Germany, who have already declared that all their fines will be between 2 and 4%, which is really nice of their regulators to say that. But it's not entirely flippant. You do need to take it seriously, because there will be audits, and all the regulators are gearing up for that. So this is actually how the principles have been recast. You've got to have lawfulness, fairness, and transparency. And I mentioned lawfulness very importantly at the beginning, because in fact, the one small area of independent implementation across Europe is how each country in Europe will define lawfulness. And I should have said this at the beginning, I'll come to it at the very end. When I talk about Europe, I deliberately talk about Europe because it's everything west of the Urals. The European Economic Area is what this covers. It's not simply the EU. And so therefore, anywhere in Europe that you're operating, you do want to be keeping these things in mind. But different countries have different attitudes as to what is lawful behaviour. And there is where you will have variances across Europe. Otherwise, it's fairly obvious stuff. It's about making sure you've got the right purposes. Data minimization is about not keeping more data than you need. So the old system of basically you just keep adding things into your computer system and you never clean it out and you never throw it away. You've got to think a little bit differently about that. And there are bases for keeping data. I think in the election cycles, we'd all appreciate that it can be quite useful to keep old election data, looking for trends over periods of time. But you have to be able to justify that, because if you can't, again, the starting position of the regulator is the election data you've kept is 4 years old. Why have you kept it? It's not relevant. Get rid of it. Accuracy is very important, and anyone who's ever had to deal with a database knows that maintaining it in an accurate format is a real challenge. But again, this is something the regulators will be looking for. So that's the heart of the principles that you need to be keeping in mind. So where is it all heading? Breaches are the big issue. Now you tend to get more public information on non-political ones in the commercial environment, like Equifax, who of course have a lot of data on a lot of people. They're a credit scoring company, well known around the world, particularly in the US, and they've had a huge loss of data. There are some more potentially embarrassing ones. I'm sure no one in this room would know any great detail about them, but there's a company called Ashley Madison who specialise in introducing people to one another. It's an amorous form of Facebook in some respects, and they had a major data breach. So, you know, in PR terms it's a nightmare, in financial terms it can be a nightmare, and some of the new aspects of the regulation are that now when you have a breach, what you find that has happened in the past, Yahoo had a major breach, and they sat on it and kept it secret for over 12 months until somebody whistle blew on them. You can't do that anymore. If you do it, you are really going to get knocked sideways. And that's been one of the things in the past. When you look at the present regulations and the present scheme, you have a breach, you think about it internally, and you debate, should I tell the world this happened? Well, now, if you don't tell the regulator within 72 hours, that's another automatic fine. And the truth is that you can't keep data completely secure, so people have to think about their public relations in a different way, because it's not just a legal issue, particularly in our environment of politics. The damage that could be done to your candidate or your colleagues or your party by having a breach that you don't handle effectively in the public domain will have enormous and negative consequences. So, you've got to demonstrate compliance. You need to have processes, policies, procedures. You have to have rules on retention. The truth is, it's actually very formulaic. By all means, look to your lawyers and others for advice, but the truth is that once you've got the advice, once you understand the heart of it, I don't think it's that difficult to maintain compliance systems, but you can't ignore it, because if the regulator knocks on your door today, you have the advantage of being able to turn around and say, oh, you know, we're well behaved, and then you can sort of look back at your records and you'll be given some time to say, well, we've got an opt-out, we've got an unsubscribe button and so on, and you put a little dossier together to show that you may not have had it nice and neatly stated in any particular place, but you were good citizens. That's not acceptable, because now when the regulator knocks on your door, either because they've had a complaint from somebody or because they're doing a random audit, they expect you, within a matter of minutes, to open your physical folder, open your electronic file and say, here's my policy, and not just my outward-facing privacy policy, which you would have on almost any website, or your cookie policy if you're dealing with the Europeans. It's your document retention policy. It's your policy on how you notify within 72 hours and who in the organisations makes the decisions. These sorts of things are not public. These are not known outside. And if you don't have them, again, automatic fines. Everything's about a fine. So you've just got to be ready for all of these particular aspects coming down the line. Let's talk about one or two of the particular articles that may cause some problems. First of all, Article 6, this lawful processing, I've touched on that already. I've given you the heart here of what constitutes lawfulness. The magic answer is number one, consent. And for most people dealing with the present regulatory regime, that's what they focus on. It makes a lot of sense. You know, when you meet someone or you get to sign up through a website, you have one of those tick boxes that says, you know, tick here to receive messages from us and so on, and you audit that. That's fabulous, that's wonderful. However, as many of you will appreciate in the political environment, depending on your country, it's not always easy to get consent. You know, it's an odd dichotomy, certainly in this country, when the public at large do want to hear what their choices are when it comes to an election, but they don't tend to like you knocking on their door and talking to them and interrupting dinner time or anything else. And the number of people who are willing to sign up to political messages and give that obvious consent is actually relatively small. It's a genuine challenge here in the UK, and I suspect it is for others in other places. And consequently, getting consent for this is not always straightforward, and therefore people have relied on other aspects. You can have contractual and legal obligations. And the bottom one, legitimate interest. Many people think political engagement is a legitimate interest, but I'm afraid I'm here to tell you that's wrong, and our politicians have been ignoring it. That is because, when we get on to Article 9, data is now being categorised. In some parts of Europe this has happened for some time. The Spanish have always categorised their data in some depth, the British typically not. And as with all things European, there's a wonderful menu across Europe of what the attitudes are. But now, these are the standard categorisations that the whole of Europe will honour, and I've put in red number 2, political opinions. And it's interpreted very, very widely. So absolutely anything you've got in a database, if you're a political consultant, if you're a member of parliament, if you're a councillor, if you're in a political party, the fact you've got somebody's information and you are politically engaged, it falls in that bucket. That's the very broad understanding, and that is the way it will work. Consequently, you're into the special category, which means all of the standards, all of the regulations get heightened, and you have to have better procedures and security arrangements and ways of dealing with these matters than just the guy who owns a local pizza shop and happens to have a delivery customer order list and occasionally sends out a flyer offering 10% off his pizzas, where you can sort of imply the consent because they're a regular customer. You can't do that with political. You have to have much more explicit consent. So when you get down to the bottom, what I've noted here is it's already been stated in the guidance of most of the European regulators. Explicit consent is necessary because legitimate interest is not sufficient when you are dealing with these kinds of data. So it's much harder for you to justify the legitimate use of the data without that consent. Just to make sure that everyone's got some basic understanding of what on earth I'm talking about when I talk about data and processing, I wanted to run you through the key definitions. processing, quite frankly, it's up there saying it's obtaining, holding, and so on. Quite frankly, in today's world, if you've simply got data on any electronic device, I can see plenty of them in this room, that's processing. You don't actually have to be doing anything. The mere storage, the mere holding of that information is processing. And it used to be that there was an exemption that if you were still old school and kept everything on paper records in a filing cabinet, you didn't get caught. But that's no longer true either. So it doesn't matter how you hold that information now. If you hold it, other than in your head, it's processing. We also had a very important distinction historically between data controllers and data processors. Not knowing precisely who's represented here in the audience, I believe having looked at the attendee list and knowing how things work, quite often you'll be a political party or an agent or a candidate and you will outsource, you will hire in somebody to organise mailings for you, or to manage databases, or to hold events. Now in that scenario, the candidate or the political party will be the controller and they're telling someone else what to do. And contractually, as the processor, who's simply paid to carry out a task, you didn't have to worry about this stuff. So it's not down to me. I'm doing as my contract requires. I've been hired by Theresa May or Jeremy Corbyn or Donald Trump or whoever it is to do this for them. They're the controller. Regulator, go talk to them. Regulator, only find them. I'm a mere processor. One of the big shifts in the regulation is you can no longer do that. You can put up some firewalls. Under contract, you can put most of the emphasis on the controller, the person who is engaging you for this assistance. But now, the regulators say, no, the truth is, most of the breaches, most of the problems in the last 15 years are with those actually doing something, sending out communications, manipulating or doing data analysis, and they tend to be the processors. So we're not letting the processors hide behind that contractual arrangement anymore. Consequently, whether you're a controller or a processor, you have some risk. So going on, again, to the basic definitions, what is personal data? Well, personal data, effectively, it does have to link to a live human being. There's some very interesting cases, and I've been involved in some, concerning the recently departed, where family members are unhappy, particularly famous people. They're unhappy about what's being reported about a loved one who's died in an accident or whatever. Generally speaking, the regulators have focused in, and I think even more so they will continue to focus in on those individuals who are alive. But if you've got anything that involves a recognisable, identifiable human being who is European, and they can be European living abroad, if they're European they get these rights, then it's anything, their phone number, their email address, just who they vote for. The connection of one piece of information against an identifiable human being, that's personal data. Processing is just about anything. I've already told you it can be just as simple as holding their name in a database. And geographical scope, this is where I do the analysis to the way the US Department of Justice and certain other US agencies have historically acted, which is not historically the European attitude. We've been a bit more respectful of the boundary and said it's in Europe and we recognise we can't tell the rest of the world. But in relation to data, they've got a different view. Now, the way they'll punish you is that most global organisations typically do have a presence in the US and a presence in Europe. And so long as you've got something, and in particular, if you bank with any bank that is international, they will have a basis in Europe, and that's how the regulators will get you. It's effectively the expurgation of what's known as the worldwide freezing injunction, pioneered by the English. Not always popular, but it just means that effectively, even if you're outside of Europe, in order to do business in Europe safely and not run some risk, you do need to pay attention to this. So, I'm going to skip on a bit because I think I may have been going longer than I'm allowed. But you have to start with what is personal data and recognise pretty much everything you're doing is political and therefore sensitive. The legitimate interest requirement won't be enough to save you. And in any event, there's a two-step test you have to go through. Because the first thing is you have to have the information on a legitimate basis, and you have to be able to justify that. It's not stated what a legitimate interest is, but you have to be able to stand up in front of effectively a regulator or a judge, because they're the ultimate arbiters, and say, I think what I'm doing is legitimate for the following reasons. But that second part is it's got to be balanced against the individual's interest. And if the individual has ever said in any public forum or in any unsubscribed, I don't want to hear from politicians, you'll fail on that test, which is why the consent becomes so important. And the problem of getting that consent is just getting harder and harder and harder, because a lot of people have historically tried to do implied consent, have an email exchange, and they put at the bottom of the footer, if you ever respond to me, or contact me, that's implied consent that you're happy to hear from me again. The regulators aren't happy with that anymore. It's got to be explicit. And so, for example, you can't have a website that allows people to sign up where the box that you tick to hear from the party is already ticked, and it's untick it if you don't want to hear. It's got to be the other way around. It's got to be opt-in. And the regulators are getting hotter on this. An example, in 2015, the UK regulator took enforcement against the Better Together campaign. It was one of the referendum campaigns on our future with Europe. They didn't have the right consents. They deemed that to be a marketing breach. They were fined. And so that's under the present law. It's only going to get sorted out in May. Our regulator here in the UK has given some guidance on this. Other regulators have done the same. Forgive me, my French and German is so bad I wouldn't trust actually standing up here and running through theirs, but I will run briefly through the UK's. But it's pretty obvious stuff, and it's all rather depressing if you're in the game that we're all in. You can't send marketing emails, you can't do telephone calls, you can't do automated calls. It's just a long, long list of things you can't do. Also here in the UK, I would alert you to the fact that all of the major political parties are subject to High Court injunctions against any form of automated telephone calling because they've all tried it without paying attention to this, and they've all been subject to court orders against them. When you're collecting information, you've got to be very clear about your privacy notices, so you can't do that in a sort of subtle, long list of things at the bottom, and you need to make sure that everybody understands what they're getting into. All the regulators have these kind of guidance notes on them right across Europe. That's the UK website, but it's no different when you deal with the Spanish, Belgians, French or otherwise. Here's the big shift, Article 30. It'll be called different things in different countries, but this is about the record keeping. This goes back to what I was saying earlier. Basically, the sound approach is once a year, you need to ensure you've done some sort of audit. You need to keep some records. You need to show, have we done some training? Who is the controller? Have you appointed a data protection officer? This is a slightly new concept. It's not particularly new to the British. It was actually something that we came up with and the Europeans have adopted, whereby you have a designated person in your organisation who's responsible, same as a company secretary or some other kind of officer. A lot of people are scared of it because there's some personal skin in the game. If they aren't doing their job, they aren't signing off once a year that you've done an audit, you've done some training and so on, they are personally liable. On the flip side, to try and encourage one or two of you to take on the role, because it won't work if you don't, you have security of employment. You actually have to have the right of fearless integrity. You are basically allowed to tell your employer that they're making a mistake and they're not allowed to sack you for it. It's a bit of an unpleasant one to go down, but it's actually quite an important new role. And you need to understand about how long you're going to keep data for. You need to think about this for the whole of the European Economic Area, and you need to think about your security measures. And effectively, there's a specific regulation for these data protection officers. These are the people in your organisation who will keep you safe and honest. Security, this is the seventh principle as it stands. The concepts aren't changing, and in practice, you've now got to put a bit more effort into thinking about the design. A lot of people don't give any thought to this. They have a laptop, they walk around. You may all have spreadsheets, Excel sheets or otherwise on the devices in front of you. And if you're walking around carrying any data in relation to any European citizen on it, is your device sufficiently secure? How easy is it to hack? Do you have passwords? Do you have standards? Do you have requirements? A lot of people get into trouble because somebody's commuting and they leave their device behind and it gets hacked. And if you don't have the right policies and procedures, you'll get into serious trouble because directors of companies in the UK also have personal liability for all of this stuff. That's under our present law. That's not changing. Finally, let me get into some of the, it's just a very depressing topic, isn't it? Here's some examples of what the regulators have been doing. The ICO is looking at the activity in the last two elections that we've had, in fact, the last three elections, because we're into elections right now in the UK. I think the population's had enough, but the politicians have been having a whale of a time. We had a general election in 2015, another one in 2017, and we had a referendum. And our regulator is investigating all of them. And they're having a go at people for not having clean consent lists. They're having a go at people for not doing the appropriate checks before doing data analysis. And again, Better for the Country was fined another time. Better for the Country is better known as the Leave EU campaign. All of their policies were non-compliant, and the regulator's been having some fun with them. One of the examples that was published, because the UK regulator doesn't publish them all, they sent 500,000 texts, and they were fined £50,000 for that. I would urge you not to do an economic analysis and think I can afford to pay those fines, because the fines are going up. But the point is, they're not against fining you. And on the back of this, you have to now be aware that once you've had a breach, you need to react quite quickly. You've got 72 hours. One of the big challenges for those I work with a lot of North American companies that supply services to Europe. The regulators here give no leeway for time zone differential. So if you need to talk to your IT people in California, you're going to lose 8 hours. And that's 8 hours out of 72, and that's a real problem. And you need to think about that, and you need to therefore know how you're going to be able to get hold of people. And you need to also have a little bit of redundancy in your system. People will be sick, people will be on vacation. You need to have the right people available to answer the questions. Otherwise, again, automatic fines in the multi-millions of euros. So, we are very nearly there. I've only got 2 more slides. Transfers outside of Europe, a genuine problem. Those of you in America will be aware that there used to be something called the safe harbor. It was always a bit of a joke. I'll tell you the real problem we have, and it's a conceptual difference in terms of the respect for law enforcement and investigation between Europe and the United States. I represent a lot of US companies. It is more acceptable in North America that if somebody turns up with appropriate identification from the FBI, I had one incident with a sheriff out of Missouri that happened to turn up at a small IT hub, and he said, I want to have a look at your servers, I want to look at what's going on, I'm investigating some bad. I'm not worried about you, your company's fine, but I think your company has been selling some IT software and you might have useful information for my investigations. And in America it's much more acceptable, and you're unlikely to get into such trouble if you share with legitimate law enforcement agencies. The Europeans do not think that is acceptable. You have to have court orders, you have to have subpoenas, and it is a constant tussle. And that is the heart of the problem between us in terms of data respect. So it's too important to cut off the data flow transatlantic, and therefore we have something that came in called Privacy Shield, but the fact is, it's hanging on a thread. There are 2 Irish court decisions that have been held back and held back and held back, because I know for a fact they're about to say it's not sufficient. The European Commission has said it's not sufficient, and it's only the importance of the economic flow that means that the politicians are sort of sticking their heads in the sand. But at some point it's going to change. So it's not so bad for commercial data, but the politically sensitive data after May, hosting it on US servers is a genuine problem for Europeans. It's why so many people are choosing to still work with American companies, but try and ensure that they're using some European servers as a way to avoid getting into the debate on this issue. So, last quick part, pictures of sorts. Lawyers don't do pictures. Just to relieve the team of all the words. This is just so you understand the structure. Court of Justice of the European Union will be the ultimate arbiter on all of these matters. National courts right across Europe will make decisions about data protection acts and what has happened. And so the first port of call is all the regulators in all of Europe will be able to go to their local court, but if there's any debates, it'll go up to our effective Supreme Court. And a couple of new things. The European Data Protection Supervisor, relatively new concept. The European Data Protection Board, that's growing out of some committees that exist in Brussels. They're going to be like super regulators, and they're going to be guiding the whole of Europe. And when the British leave the EU, the attitudes may be more French, because it's typically been a French-British tussle. The British tend to take an approach of reasonableness, and if you've got reasonable explanations, our regulators don't tend to find. They're actually one of the lowest fining regulators in Europe. The French, a little bit different. Consequently, it'll be interesting to see how that develops post-Brexit, because the UK will have a say on this board, because it's more than just the EU, but we do expect a bit of a shift in direction. So, ladies and gentlemen, that is a rapid run-through of data protection. Consider yourself mildly educated, I hope, and if we have the time, I'm happy to take a couple of questions.
Yeah. So, has anyone got any, we haven't got long for questions, so if you can keep the answers quite brief.
Okay, so you did say that we can't just say that having data for political targeting is a legitimate interest. Do you have any examples of what would be considered a legitimate interest?
I'm afraid in the political sphere, nothing. Consequently, there is an amendment that's been proposed to the UK data bill, which will shortly become an act of Parliament, to try and address that, to make clear that democratic engagement can be deemed a public interest consent. Now, if that gets through, That won't alleviate all the other things about having audits and security systems, but that will be how, in the UK at least, we'll deal with that issue. Because I'm afraid that all the guidance and all the direction of travel is that sensitive data, the regulators are uncomfortable with that being covered by legitimate interests, whereby those processing the data decide for themselves what they do. They really want to see the consent, and getting the consent is a challenge. So that's what the UK is looking at doing. It's been tabled, and we see whether or not that's accepted.
So what about fundraising? Like, if somebody has made a donation last year to a British organization, they may or may not have opted in or whatever. Is that a legitimate interest?
So in case anyone didn't hear, that's a question building on the last about whether or not fundraising is treated any differently, and I'm afraid no. In fact, that's a genuine and major problem. Further guidance notes may have been written by someone sitting on this stage to the government to issue via the regulator and the Secretary of State to say that all forms of democratic engagement, if the recommendations go forward, should then have a final rider that says all of the foregoing are covered for fundraising to achieve those purposes. But again, if that amendment doesn't get through, then fundraising is also a major issue of concern as to how you deal with it if you haven't got legitimate consent. In this country, most of the political parties have particular fundraisers that are sort of closely aligned with their parties, and they probably will be able to get effective consent, but in a general sense, you won't be able to rely on legitimate interest.
Simon?
Data transfer is obviously one of those things. So as a political party, you send your activists out to canvass, and normally they get given previous vote history, some issue information, etc. Is that something that isn't going to be possible under GDPR? Because that volunteer isn't a member of your organisation, they're not an employee, there's no contractual relationship.
One small piece of good news for you, that's fine. I think that there is actually an over-excitement in the political sphere amongst the major political parties. I've heard them talking about the need to no longer do paper-based clipboard knocking of doors and canvassing, which is how it typically happens in this country, and making everybody do it on sort of secure, party politically controlled iPads and so on. That's over the top. What the problem is that there's not enough people that are familiar with IT security and these regulations in any depth, so they're guilt-plating it. The truth is, these regulations aren't designed to stop you processing. What they are designed to do is to give greater respect to the individuals concerned. And our genuine problem is that people do want to hear from their politicians, they do want informed choice, but they rarely want to sign up to hear from you. Politicians are not popular people. And that is the problem. But it's about appropriateness. So therefore, if you send someone out with a clipboard, so long as you've told your volunteers, I mean, the main thing is about training. You insulate yourself from most of these problems by making sure you offer everybody training and you keep some records. If the odd person hasn't been trained, that won't be a problem, certainly with the British regulators, so long as you've clearly offered it and you've trained most people. But you can no longer rely on, I didn't know.
Yeah. Last question. Tom?
How do you prove compliance, and with which jurisdiction? Obviously, I've got German voters, I've got Save the Hospital campaigners in France and things like that. Do I need new policies for each area? How does it all work?
Happily, 97% of data rules across Europe, and not just the EU, the whole of the economic area, so Norway and Switzerland and Liechtenstein and so on, they're all uniform. And therefore, I mean, I work with a lot of global companies, and I think actually one of the things I really do think is very important is you try and have the same policies, because you don't want in your organisation lots of variation. No one will remember the variation. Keep it simple, keep it harmonised. So actually, generally speaking, harmonisation is fine. How you prove it is a genuine challenge. I've got all sorts of clients saying, I've got an American company, my European client says, prove to me you're GDPR compliant, otherwise I can't give you any business, because my people will say I can't do business with anyone who's not compliant. How do you prove it? It's a genuine problem. There will be new systems being instituted in the UK. There'll be actually a new kite mark organisation where you can go and fill out certain things, but it's not been created yet, and May is around the corner. Right now, it's a little bit of a boon for quality lawyers. It is a health warning because there's an awful lot of ambulance chasers out there that are peddling rubbish. But if you've got a standard advisor that you trust, one of the things you can do is have them come in, give you a training session, get them to sign off, get them to send you a letter. You can take that pretty much to the bank and rely on their insurance policy that they've told you what you need to know. And most of my commercial clients, that's sort of the approach they're taking.
So in all seriousness, this is going to affect all of us who work within Europe, so please do have a think about it, because we don't want anyone in this room to get some of those horrendous fines. Take James's card. Seriously, take James's card, because he knows his stuff, and it's a big change that's coming. So another round of applause, please, for the real Mark Darcy over here.
Thank you very much.